that's all from me. So I'll hand over to Master Blunt now.
Good afternoon to all. Thank you for logging in. This will be quite long, but I hope it will be interesting, and I hope that you don't regret having logged in. You are, of course, in the fortunate position of being able to log out if you want. So the talk is being advertised as members of the Inns and Movements for Independence. And the idea behind the talk comes from the fact that there is a significant number of students who trained at one of the Inns of Court over the centuries, who went on to make a significant political impact in their home countries and also on the world stage. Mulling this over one day, I wondered whether the Inns could claim that they had played a part in the development of the ideas which motivated these individuals, or in giving them the skills which they deployed in the pursuit of their political objectives. Before I had done any research into the question, and in an unthinking moment, I agreed to give a lecture on this topic. Hence, here we are today. Now, because there is quite a lot to say, I'm going to divide this session into two parts and give myself and everyone else who has logged in a 5-minute break between the two parts. So here we are with part one. Who am I talking about? Some are still recognizable world figures, some are not. Examples of the first category would include such names as Mahatma Gandhi, Muhammad Ali Jinnah, both Gujaratis, Nehru, Tunku Abdul Rahman, a leader of the independence movement in and first Prime Minister of Malaysia, and Lee Kuan Yew, the architect of modern-day Singapore. Those are all names which I think most people today would recognize. In case you're wondering about the reference to Gujaratis, you should know that my wife of 45 years is a Gujarati, and I'm keeping a score. The list of names falling within the second category is a long one. It's too long to be recited in this session, but I'm going to give you a few names, a small cross-section. From the Inner Temple, Seretse Khama, admitted 1946, first president of Botswana, formerly Bechuanaland. Mary Eugenia Charles, called in 1947, Dame of the British Empire, co-founder of the Dominican Freedom Party, campaigner for independence, Prime Minister, and also later known as the Iron Lady of the Caribbean. Frini Jinwala, called 1964, anti-apartheid activist, built escape routes from South Africa after the banning of the ANC in 1960. She established the ANC office in Tanganyika, as it then was, helping ANC leaders, including Mandela, to travel in and out of South Africa. And after his release, she became Speaker of the National Assembly for 10 years. Shayanji Krishna Varma, Indian revolutionary, called in 1884, disbarred 1909, reinstated in 2015. Solomon Bandaranaike, called 1924, founder of the Sri Lankan Freedom Party in 1936, independence in 1948, Prime Minister 1956, assassinated 1959. From Lincoln's Inn, Zulfikar Ali Bhutto, called 1953, fourth President of Pakistan and Prime Minister, founded the Socialist Pakistan People's Party. He was a controversial figure because of actions which led to wars with India. He was usurped in a military coup in 1977 by General al-Huk, and he was then executed in 1979 following a trial for allegedly authorizing the murder of a political opponent. That was a trial which has been regarded as essentially a judicial murder by a Supreme Court of packed or intimidated judges. Chaim Herzog, called 1918, born in Northern Ireland, moved to Palestine in 1935, Zionist, soldier in the Haganah and in the British Army in World War II, called to the bar in 1942, ambassador to the United Nations and the 6th President of Israel. Alfred Mangena, called 1909, political activist and co-founder of the African National Congress Party in South Africa. From Gray's Inn, Sir Grantley Herbert Adams, called 1923, power behind the Labour Party in Barbados and the trade union movement in the Caribbean. He promoted much social legislation and is attributed with dethroning the so-called plutocracy in Barbados, and he became the Premier of Barbados. Leslie Gunawardene, called 1933, Sri Lankan independence activist and founder of the nation's first political party, the Lanka Samasaja Party. There were also 3 presidents of Cyprus, Spyros Kyprianou, Tassos Papadopoulos, Giafkos Klerides. And then Bar Moore, called 1923, outspoken advocate for Burma Home Rule, first premier under British rule, imprisoned for sedition in 1940, freed by the Japanese in 1942, headed a puppet government under the Japanese. When the tide turned in 1944, 1945, he fled to Japan. He was arrested and imprisoned there by the Allies, then released and returned to Burma in 1946. He remained politically active, but spent another 3 years in detention after the takeover by General Ne Win. And lastly, from the Middle Temple, John Rutledge, called 1760, one of the founding fathers of the USA and founder member of the Supreme Court, after whom the Middle Temple's advocacy floor above the Middle Temple Library is named. And Isaac Pixley Karseme, called 1910, more about him later. And lastly, an interesting character, Krishna Menon, who is well known to my generation, but probably not to the present generations, called 1934, Indian nationalist and defense minister, close friend and colleague of Nehru, acted as a emissary between the Indian leadership and the British in 1946. He wrote the first draft of the preamble to the Constitution of India and initiated the idea of the Constituent Assembly of India. He was noted for his eloquence, brilliance, his obvious sense of superiority, and his general abrasiveness. He was the author of the Indian policy of non-alignment. He was described by Eisenhower as a menace. He was also known as the world's most hated diplomat and the inventor of the diplomatic version of speed dating. In England, apart from being High Commissioner in 1950, he also helped to found Pelican Books, and importantly, the India Club restaurant in the Strand, which I recommend to Middle Templars for its authentic and relatively inexpensive cooking. So do they have something in common? It will not have escaped you that apart from having done time at one of the inns, perhaps ironically, the majority of those whom I have named made their principal marks in the pursuit of independence and decolonization and to the unraveling of the British Empire. And this led me on to the further thought. If what they succeeded in doing can be attributed, even in part, to their membership of one of the inns, one could say that the inns contributed to the fall of the empire. A positive good or a positive bad, depending on whether you are in the imperialist camp or the anti-imperialist camp. And an idea providing scope, perhaps, for a touch of Schadenfreude, at least in some quarters. And this leads to some more questions. Is there any evidence to support this conceit? That question involves looking at the individuals concerned and asking a number of further questions. What was the particular outcome to which he or she may have contributed? Did he or she actually make a significant contribution to that outcome? If so, what was that contribution? And lastly, did that contribution involve the exercise of ideas, knowledge, skills, or other advantages acquired qua his or her membership of one of the inns? And now coming to the my choice of individuals for closer examination. There will only be time to spotlight just 3 of the many individuals who qualify, who after leaving the inns made a significant impact on the political direction of their home countries and all the world. I have chosen 1 from America, 1 from Asia, and 1 from Africa. I've not confined myself strictly to the struggles directly against the government from Westminster, though all 3 come from territories which were at one time subject to British rule, parts of the empire. Now, on one analysis, there were in fact 2 empires. The first spanned the period from the end of the 15th century until independence, the independence of the 13 American colonies, confirmed by the Treaty of Paris in 1783. The second, following the loss of those colonies, was based on the commercial and territorial expansion into Southeast Asia, Africa, and beyond. So I'm going to address first America and the First Empire. The index event which I have chosen is, of course, independence. It is, I think, common ground on both sides of the Atlantic that the revolution was led by professional lawyers. The British colonization of North America began in the early 17th century. And from before the end of that century, young men were sent by wealthy families to the Inns of Court in London to study law and qualify at the English bar, and then return home to practice in the colonial courts. Qualification at the bar in England was thought to add, if nothing else, some additional prestige to their names for when they took up their careers at home. And this pattern of Atlantic crossings in pursuit of a legal qualification continued up until and even after the Declaration of Independence in 1776. Apparently by 1815, some 200 young men had followed and completed this course. There is no doubt that a significant number of this cohort from the inns were at the forefront of the movement for independence. By way of example, the beginnings of concerted action by the 13 colonies may be traced to the so-called Stamp Act Congress of 1765. Of the 27 delegates at that Congress, 5 were Middle Templars. And of these, I have chosen John Dickinson, one of that 5, to be put under the microscope. So next, Asia and the Second Empire. Students from the subcontinent began coming to the inns for legal training in the 19th century. Like the American colonists before them, most, if not all, subsequently returned homes to practice. Between 1862 and 1885, 108 young men had pursued this course, encouraged by the government in India and by the inns, which granted financial concessions to facilitate their training. They were followed by students from further east, and the numbers of students from South Asia continued to grow until quite a few years after their home countries had achieved independence around the middle of the 20th century. The signal event marking the beginning of the end of the Second British Empire was perhaps the termination of British rule over the Indian subcontinent and the creation of the states of India and Pakistan. This is the outcome in Asia which I've chosen. Again, perhaps the most prominent leaders of the independence movement included lawyers who had passed through the Inns of Court. And for detailed scrutiny, I've chosen Gandhi, who was admitted to the Inner Temple twice. So far as Africa is concerned, the individual whom I have chosen to spotlight in this session is Isaac Pixley Lakaseme. I am prepared to take a bet that none of you have ever heard of him. However, he has a claim to be the one who started the long walk to freedom in South Africa, which is the outcome in the continent of Africa, which I have selected. My next point is that the chosen three had common objectives. I'm referring to the bundle of rights and rules enjoyed under statutory and common law rules that make up the British Constitution, underpinned as they were and are by the concepts of natural law, conferring innate individual rights, and of government based on the consent of the governed. These are all concepts which can be traced back to Magna Carta, Coke, the Bill of Rights in 1689, and the era of John Locke at the end of the 17th, beginning of the 18th centuries. In their ultimate form, the objective of the independence movements in both North American colonies and in India was firstly to bring about the end of rule from Westminster, and secondly to introduce local democracies in which individuals would enjoy equivalent rights and liberties to those conferred on the inhabitants of Britain under its constitution, including, of course, equality under the rule of law. The ultimate object of the freedom activists in South Africa was essentially the same, though directed against the white government and not against British rule, which ended in South Africa in 1947. Now, securing these rights for the peoples of their own countries might be described as the big idea behind perhaps all of the independence movements. And it's plain that these basic principles were factors which were well understood by all three of my selectees, and in their motivation being the desire to obtain for their own people the benefits of the application of those principles. And it's worth highlighting that in addition to being formative of the aspirations of activists, the rules and rights enjoyed under the British Constitution could be and were recited and deployed, firstly to support the justice of the cause and their actions, and secondly to persuade others to join in with the pursuit of their goals. In relation to American independence, Chief Justice Taft stated, "When the revolution came on, the legal atmosphere of every community was permeated with the principles and methods of the common law." So we come to the critical question: was membership of the Inns of service to them in their later political lives? And this predicates a number of further questions, firstly relating to legal education. What influences would these students have come across in the Inns? What subjects would they have studied? What areas of law? In particular, would they have studied those areas of law which could go hand in hand with political theory, individual liberty, John Locke's concept of government based on the consent of the governed, restraints on the executive, etc. In short, constitutional law. What teaching or training would they have had in terms of analysis and reasoning, of advocacy or oratory, or less glamorously, of drafting? So some consideration of the history of legal education at the Inns is required, and I'm afraid it takes a little time. Starting the era prior to the 18th century, we are told that by the beginning of the 16th century, the Inns of Court had developed, or had been compelled to develop, effective systems of legal training. Students were actually resident in the inns and acquired their learning and skills in lectures given by readers and as participants or observers of legal arguments called bolts and moots. There are references from time to time over the centuries of practitioners having pupils as early as 1486. It seems that at one time, 7 years training was required in order to acquire the rights of audience in the courts at Westminster Hall. Turning now to the 18th and 19th centuries, it is the general view that by the beginning of the 18th century, the inns had ceased to provide any effective training, that there were no examinations, that mooting had died, that all that was required to qualify to be called to the bar was to eat the requisite number of dinners as proof of residency at the inns. One can quibble with the comprehensive negativity of that view, the belief that there was no examination system seems to be questionable. In a letter written home in about 1748, one of the students from America reported that his call had been delayed because he had been unable to perform certain exercises. And I quote from the letter, "Every student before he comes to the bar is obliged to perform 6 vacation exercises, 3 candlelight exercises, and 2 new-in exercises, which he's not allowed to do alone, but must be joined with another student. And luckily for me, the gentleman who was my companion could not attend at the time appointed for the performance of one of the vacation exercises, which obliged me to defer that duty until the next vacation." This does suggest that there was more to qualification than simply eating dinners, but I've not carried out any research to establish how much significance should be attached to this snippet of information, nor have I any idea what vacation, candlelight, or new-in exercises were. But plainly, it was some kind of examination, and an examination of performance. There is also, I think, a question mark over the view that moots were extinct in the 18th century. Some scraps of paper found in the Middle Temple archive in the recent past set out hypothetical cases intended to be mooted. These papers bear the signatures of Thomas Hayward, later a signatory of the Declaration of Independence, and C.C. Pinckney, a signatory of the Constitution. Pinckney was called to the bar in 1769, so this provides us with an approximate date. It's possible that such exercises were organized by the students themselves rather than the inns. But one American academic at least, Joseph Kelly, to whose views I will return, refers to there having been moot courts, and he's referring to the 18th century. Nevertheless, putting these quibbles aside, it is clear that by the 18th century, the inns had ceased to provide any system of lectures. Whilst Blackstone began lecturing in Oxford in 1753, there's no record of his having done so in London. His lectures were absolutely nothing to do with the inns and were privately paid for. There's also evidence that in the early 19th century, Joseph Chitty Sr. of the initial edition of Chitty on Contracts and numerous other textbooks, there's evidence that he delivered lectures, some in Lincoln's Inn Hall, but these too were private. So again, nothing to do with the inns. Again, it's clear that there was no system of pupillage and no advocacy training as we know them today. Although this all looks pretty dire, in practice, there was a well-established but informal system of training, or at least a voluntary educative routine, albeit not prescribed or orchestrated by the inns. So the inns really can claim, as will appear, very little credit for that. Firstly, in this informal system of training, there were books. In the absence of lectures, students who were serious in earning a livelihood as barristers learned the law from books, studying alone or with one or more fellow students. In fact, the number of law books available in the 18th century, as evidenced by publishers' catalogues which survive today, is surprising, certainly to me. The title best known today, of course, being Blackstone's Commentaries, first published in the mid-century. But the commentaries were preceded by numerous abridgments of the law, students' companions, and other legal texts and treatises. And it may be that the old system of lectures given by the readers of the inns had decayed simply because of the ever-increasing availability of books following the development and expansion of printing. But that's just speculation on my part. Some, at least, of the American students brought the books which they needed and took the books home with them when they returned. But all the inns had their own libraries, and the archives of the Middle Temple relating to the 18th century show that the library held an extensive range of law books, including Viner's mammoth general abridgment of law and Equity, which I think ran to either 14 or 24 volumes. And the libraries of the other inns may also have held similar stocks of books. Secondly, the courts served as schools of law. There being no formal advocacy training, students learned by observation, attending the law courts at Westminster Hall on a regular basis, going out on circuit, having the opportunity both to listen to legal argument, to witness live advocacy, and also to attend debates in Parliament. And this was so much a part of their learning that Lord Mansfield actually reserved seats in his court for law students. It's an area which came to be known as the crib. Dickinson, in one of his letters, to which I will return, described Westminster Hall, where the common law court sat, as a school of law. And the value of just sitting in court and listening is not to be underestimated. This was the way in which the generations who were called to the bar prior to 1994, which was when the inns introduced formal advocacy training, that was the way in which those generations, including me, learned our oral advocacy skills, brackets, if any, close brackets. Firstly, by sitting in court, observing and listening, and secondly, by trial and error. So the University of the Law Courts was to those students of the past, especially a subset of the University of Life, and it remains so today. Sitting in court remains one of the greatest learning opportunities that a student or young lawyer can find, and it is free and much to be recommended. Thirdly, informal pupilages. There were no pupilages as we know them today. They only became mandatory in 1959. But some students hired private tutors, who it seems were not necessarily barristers. These tutors would have helped direct their studies, assist them in understanding cases and principles, and may have assisted them with drafting and public speaking. Joseph Chitty Sr. certainly took pupils in the early 19th century, and he may not have been the first to do so. Fourthly, there is the collegiate experience. That is the experience of eating dinners in common with barristers and judges. Over the centuries, the one constant of membership of the inns has been the opportunity for discussion between students, practitioners, and judges, provided by the dinners which they all attended. For students, it would also be a networking opportunity. Although the suggestion that this opportunity constitutes a benefit of any substance is now regarded by outsiderism, and whatever the position now, there is material to support the view that it was regarded by students, at least until Gandhi's time, as a valued feature of membership of an inn. In a letter to his father in 1754, John Dickinson wrote, "Since my last, I've entered into commons, that is dining in term time with the barristers and students of the society in the public hall. We always have with us some of the governors who are called benchers, and frequently some of the judges and greatest lawyers." Dickinson plainly believed in discussion with others as a valuable educative tool. So it's unlikely that he and others like him failed to take advantage of what he saw as an opportunity to learn. There is a record of two of the colonial students, Edward Rutledge and Thomas Hayward, dining in the Middle Temple Hall in 1769 with William Blackstone himself. The American academic Joseph Kelly, whom I've referred to, writing in 1980, commented that collectively, the learning opportunities incidental to the study of the law at the inns in the 18th century were, and I quote, "of immense psychological value to a young attorney when he returned to the colonies," unquote. And he included in the list of opportunities learned discussions with judges and lawyers. So the question is, did this informal system work? It's clear that the agenda for learning, which I've outlined, was not wholly inefficacious. The common law practice of lawyers at that time was to compile their own resource books their own databases in so-called commonplace books, in which they noted down legal principles and propositions from the books, treatises, and cases which they read, and from the cases which they sat through in court. Students would have done the same. In the letter to his home in America in 1754, John Dickinson, with reference to his attendances at court hearings and of debates in Parliament, wrote, "I now have the opportunity of seeing and hearing the most learned lawyers and the finest speakers. Since my last, meaning his last, some of the greatest men in England, perhaps of the world." As a result of his observations in court, he wrote, no doubt as a result of witnessing some poor advocacy, he wrote of the necessity of a lawyer's not confining himself barely to acquiring knowledge, but of qualifying himself to communicate it to others. So it could be argued, therefore, that the Inns had outsourced, not only had they outsourced some of their responsibilities, but they'd actually done so quite effectively, having outsourced it essentially to the law courts themselves. Now, moving on from the 18th century, the general picture of legal education on the part of the Inns of Court continues to be one of neglect. This gave rise to an investigation by and a critical report from a Parliamentary Select Committee in 1846 and to a Royal Commission in 1854. These did result in the formation by the Inns in 1852 of the Council of Legal Education and to the promulgation of consolidated regulations governing admission to the Inns and call to the bar. Residence was not required, but students were obliged to keep 12 terms by eating 3 dinners at their inn in each of those terms. Courses of lectures were provided, principally, it seems, by practicing barristers, at least until 1967, when permanent teachers were appointed, but attendance was voluntary and remained so until, I think, the introduction of the BPC and the Inns advocacy courses. Initially, examinations, which I believe were introduced in 1863, were voluntary, blissful days for law students then, but they became compulsory in 1872. By 1915, the subjects taught included legal history and constitutional law, and it seems likely that these were always on the curriculum following the creation of the Council of Legal Education. And in fact, there's a cutting from an issue of the Times in 1896, which gives the results, which publishes the results of the bar examination paper for Roman law, constitutional law, and legal history. As a matter of passing interest, and forgive me for wasting the time, the sort of thing which interests me, by 1915, the curriculum gave students an option to choose between real property, Roman Dutch law, and Hindu Mohammedan law. Standards were low. Gandhi, in his autobiography, reported that in his time, that is in the late 1880s, the curriculum of study was easy. Everyone knew that the examinations had practically no value. I've known many pass the Roman law examination by scrambling through notes in a couple of weeks, and the common law examination by reading notes on the subject in 2 or 3 months. Question papers were easy and examiners were generous. Those were certainly the days. But truthfully, this was still the same in 1967, nearly a century later, when I took the bar exams, which had actually little changed from Gandhi's days. At some stage, elementary drafting was included in the curriculum. But even by the time I took the bar examinations, it was absolutely rudimentary and would not have equipped students to draft anything other than a simple pleading. And as to pupillage, a report of a committee on legal education published in 1847 included a recommendation that students should spend a period of 2 years under the tutelage of senior practitioners. And there is a reference in a parliamentary debate in 1854 to a barrister having been a pupil in Chambers. As the century wore on, it may have become customary for young barristers to spend some time under the tutelage of a more senior practitioner. But you will recall that pupillage was not mandatory until 1959. As the collegiate experience, at some stage in the 19th century, the benches of the inns ceased to sit with the students on a regular basis, withdrawing to their high tables, so that by Gandhi's time between 1888 and 1891, and according to him, students and benchers did not mix after dinners, and he saw no benefit in dining in hall except for the fact that the meals were relatively inexpensive. So the question is, was there any point in joining an inn? Given the weaknesses of the education which the inns provided, was there in fact any advantage or potential benefit in becoming a member of one of the inns? The answer is actually yes. Firstly, in many of the overseas territories at that time, historically, there were no schools of law at all. I believe that many of the schools of law which now exist in the Commonwealth were set up in many cases after independence. Secondly, the inns were undoubtedly revered overseas, and call to the bar in England conferred prestige and status, kudos if you like, and the potential to be a person of influence once back at home. This is why families who could do so sent them to the inns. Before Gandhi left India to come to London to qualify as a barrister, his school held a ceremony for him of congratulation and farewell. There is a report of the ceremony held to say goodbye to him in the Kathiawar Times for August the 12th, 1888, from which it's clear that young men who went to England to the Inns of Court were expected to return from England with, and I quote, enlarged views of polity, commerce, and society, which would accelerate the progress of reform in India and ere long return her to her former glory. And as another one of my asides, one gets a local colour from the newspaper article, which concludes, quote, the party broke up with the customary distribution of betel leaves, nosegays, etc. So against that background, does an analysis of the lives and careers of my chosen three individuals from the colonies provide any support for the theory that the Inns of Court contributed to the success of the missions which they undertook? This is the question to examine in part 2. This is where I'm going to take a break of 5 minutes, so we'll resume at 1:45. So part 2, which I remind you, is concerned with the question of whether the lives and careers of my three individuals provide support from the speculative theory under examination. So first, American independence and John Dickinson. He was born in 1732, travelled to London in 1753 and was called by the Middle Temple in 757. Although he did not approve of or sign the Declaration of Independence, because by instinct and upbringing he was opposed to violence, and because he also considered it imprudent to issue such a statement at a time when there was no formally established union between the separate colonies and no certainty that in the likely conflict they could rely on the support of a foreign power. He is accepted to have been one of the founding fathers of the USA. Later, of course, indispensable backing for the revolution was in fact secured from and provided by France. By way of a brief chronology, there appears to be no significant discontent in the American colonies until 1763, when the British government sought to recover from the colonies by the imposition of new taxes some of the costs of the war which had defended them from the allied French and Indian tribes, the 7 Years' War, and also to defray the costs of providing for the continuing defense of the colonies. These taxes were resented by the colonists. And as already stated, Dickinson attended the Stamp Act Congress in 1765, and he subsequently responded with the pen in a series of letters published between 1767 and 1768 in the Pennsylvania Chronicle under the title Letters from an American Farmer. He argued that whilst Parliament had the right to legislate to regulate trade, it had no right to levy duties for revenue, and that if the colonies did not resist, the precedent would lead to the imposition of further taxes in the future. These letters were reprinted in numerous other newspapers and were highly influential in mobilizing public opinion in America. He was a Pennsylvania delegate at the First Continental Congress in 1774. This was assembled to prepare a statement of the rights violated by parliaments in 1763 and produced a declaration and resolves asserting the claim to all the rights and liberties of English subjects, and also a petition to the king, which Dickinson drafted. He attended the Second Continental Congress in 1775, which issued the Declaration of the Causes and Necessity of Taking Up Arms, which he and Jefferson drafted together. He also drafted another petition known as the Olive Branch Petition, with a view to avoiding conflict, which it is said the king did not bother to read. Dickinson also prepared the first draft of the Articles of Confederation and Perpetual Union, which joined the 13 colonies initially in a confederated state. This was approved by Congress in 1777, and it governed the relationship between the 13 former colonies until superseded by the federal constitution adopted in 1788, which is the one we know today. He attended the Constitutional Convention in 1787 and 1788. He approved the final draft of the new constitution, and since it needed ratifying by all 13 states, he promoted it to the public in a series of essays written under the pen name of Junius. So by way of summary, there's no doubt that Dickinson made a major contribution to the cause of American independence, although initially his aims had not gone so far. At the various congresses which marked the route to the separation from Britain, he brought to the cause his advocacy and drafting skills and the significant influence which he commanded following the Stamp Act Congress and the publication of his Letters from an American Farmer. After independence had been secured, President Jefferson wrote that Dickinson was amongst the first of the advocates for the rights of his country when assailed by Great Britain, and his name will be consecrated in history as one of the great worthies of the Revolution. But can any significant nexus be established between the Middle Temple and Dickinson's contributions to the cause? It is, I think, generally accepted that the spark which metamorphosed the mere distaste for the new taxation into a cause for rebellion was the concept which could be traced back through the landmarks of the Bill of Rights, the Petition of Right, Chief Justice Coke and Magna Carta, that Englishmen, wherever they were entitled to a special heritage of rights and liberties. I think it's plain that that was what motivated Dickinson. But it would be wholly implausible to suggest that he only became aware of this big idea when he came to England. In particular, because apart from the sentiment of the general population of America, he came from a wealthy and educated Quaker family, and he'd already been apprenticed to a successful lawyer in America. The lawyer, John Moland, was someone who had not attended any of the inns. It's likely that Dickinson, who was a great reader, particularly of history, made use of the library of the inn, and this may have given him access to books which he did not himself own, and this may have increased his store of legal knowledge. He plainly had the capacity to put together and make a persuasive legal argument, whether orally or in writing. But the inn, because of its general lack of involvement in the education of students, could not have played any significant part in his possession of these advocacy skills. Even if you assume that discussions or exchanges of opinions after dinner of Hall provided a learning opportunity. It's far more likely that he developed his advocacy skills from what he saw and heard in the courts in Westminster Hall, which he as a conscientious student can be assumed to have attended on a regular basis. In his letter of April 1754, he wrote to his father, "Westminster Hall is a school of law where we not only hear what we've read repeated, but disputed and sifted in the most curious and learned, nay, frequently hear things quite new, have our doubts cleared up and our errors corrected. The bar is a perfect comment upon the written law, and every great man at it is in some measure a master and instructor to these young students who have the wisdom to attend." It may be argued that listening to argument would not have contributed to his skills as a writer and a propagandist, but there is a crossover between oral and written advocacy. Both require reasoned argument and the effective choice of language and structure. Nor do I think that the inn can successfully claim that his membership and call by the inn would in his case have added significantly to his reputation, to the weight of his arguments, or to the willingness of others to listen to him. The letters published in the Pennsylvania Chronicle, by which his reputation across the colonies was effectively established, were originally anonymous. So once he became known as the author, the fact that he'd been called to the bar in England is unlikely to have added significantly to the prestige which he had already acquired. So the conclusion must, I think, be that in any credit which the inn can claim for Dickinson's achievements in the political field is speculative at best. It's far more likely that his success owed more to his attendance of hearings in the courts and of debates in Parliament. So Gandhi and the subcontinent next. He's remembered principally for his contribution to the movements, first for self-government and then for independence for India. He was called to the bar by the Inner Temple in 1889. He was disbarred in 1922 following his conviction in India and sentence of imprisonment for sedition. And he was posthumously readmitted to the inn in 1998. In a paper published by the Inner Temple on the internet, it stated that Gandhi's time in London prepared him for the road ahead, and there are those who suggest that his legal and advocacy skills training enabled him to negotiate Indian independence skillfully and without a major war. The implication of that paragraph being that those skills were acquired by reason of his membership of the inn. Rather coyly, the paper does not identify who those were who were making that suggestion, but it's clear from his own unpublished autobiography that the suggestion is far from the truth. Gandhi's principal contribution to Indian independence was not the negotiation. It was to the creation and organization in India of a mass movement in support of independence. His weapons were his determination and personal courage, the word and the pen, the example of his own conduct in the face of injustices, and his development and deployment of the tactic of passive resistance, including his willingness to accept extreme personal suffering, notably in terms of imprisonment and hunger strikes. His determination and courage, once fixed on an objective, were exhibited before he ever reached London. He had locked on to the plan of studying for the bar in London and followed it through in the face of threats of a loss of caste with knock-on consequences for his family if he ever went over the sea, threats which in the event were carried out. His courage, however, was somewhat qualified, as at first he was extremely diffident and lacking in confidence in speaking in public, even amongst his friends. He certainly did not learn any advocacy skills at the Inner Temple. There was, of course, no advocacy training. He explains in his unpublished biography that when he joined the ship to travel to England, he was unaccustomed to speaking in English and was too shy to talk to the English passengers. Once in London, he gradually overcame his shyness to the extent that he could converse when in the company of one or two others. He took 2 or 3 elocution lessons and purchased a textbook on elocution, which included some exemplary speeches. And in his autobiography, there's an entire chapter entitled "Shyness My Shield," in which he records that he did not have the courage to speak at committee meetings of the executive of the Vegetarian Society in London, of which he was a member. And even if he had written something down, what he wanted to say, he wrote that this shyness I retained through my stay in England. Even when I paid a social call, the presence of half a dozen or more people would strike me dumb. He refers to 2 attempts at public speaking when on each occasion his speech had to be read by others. After his return to India, he endeavored to practice at the bar in Bombay. He was instructed in one small case, but when the time came for him to cross-examine a witness, his heart sank into his boots, his head was reeling, and he could think of no question to ask. He told the instructing agent he could not conduct the case and someone else was instructed in his place. That seems to be the last time he appeared in a court in India, except when later he was in the dock himself. He only overcame this diffidence in South Africa as a result of being a victim of racist mistreatment and insults on a journey by train and stagecoach from Durban to Pretoria in 1894. He was goaded into becoming a political activist almost overnight. He considered that Indians should be treated as full citizens of Natal, a crown colony, but their liberties, lives, and livelihood were affected on a daily basis by systematic discriminatory laws and treatment. He determined to try and improve their situation. Campaigning on behalf of his fellow Indians, he found the courage to speak in public, even extempore, though he was always reluctant to do that. His legal skills and self-confidence were honed by a year spent in the senior barrister's chambers in Pretoria, and he became adept at producing carefully reasoned and persuasive pamphlets and arguments. And he carried those skills forward when he returned to India in 1915. His success in written advocacy or in drafting was in no way attributable to his time at the Inner Temple, because neither were on the curriculum. In fact, it's clear that his initial experience in written advocacy was gained in drafting petitions on behalf of supplicants to the administration in Rajkot after his dropout from the Bombay bar. Even before his return in 1915 to India from South Africa, his campaigns on behalf of his fellow Indians had made him a public figure, a recognized leader in both London and India. He emerged as a nationalist leader at the end of the First World War when the Rowlatt Acts introduced imprisonment without trial for sedition, which led to Gandhi's first prison sentence. And with his input, the Indian National Congress became an effective political instrument of Indian nationalism. And he held a leadership role thereafter until his assassination in 1948, shortly after independence. No one would suggest that Gandhi's organizational skills, his ability to inspire others, or his tactic of passive resistance, or satyagraha, which he stated to mean vindication of truth, not by inflicting suffering on an opponent, but on oneself, could in any way be attributable to his time in London, let alone the Inner Temple. In fact, he appears to have enjoyed his time in London and not to have experienced any racist discrimination. When he left London in 1892, he did not do so as an enemy of Britain or even of the empire. Interestingly, in his autobiography, Gandhi stated in effect that he felt a cherished loyalty to the British Constitution, that not that he was unaware of its defects, but that he thought it was on the whole beneficial to be ruled, and that he thought that the colour prejudice which he saw in South Africa was contrary to British traditions and was temporary and local. He did not expand about what he cherished in the Constitution, but it's reasonable to infer that he had in mind the British system of democracy, the rule of law, and the liberties of the individual. These enshrine the principles which drove his fight on behalf of the Indians in South Africa, and later on behalf of the population of the subcontinent as a whole. So did he learn about these while studying for the constitutional law papers in the bar exams? That's a possibility. However, it seems to be more likely that he would already have had an understanding of them by the time he left India. He attended a secondary school, Kathiawar High School, Rajkot, between 1880 and 1887, where the teaching was in English, and he passed the matriculation paper, which was modelled on the matriculation examination then in England. Surprisingly, the records of the school are still in existence. The history and geography paper which he took for the matriculation included the question, what events led to the American War of Independence? Which clearly points to the fact that the curriculum would have involved the study of the constitutional principles and individual rights which the American rebels made their cause, and hence of the British Constitution also. It's obviously possible that in spite of his low opinion of the standards of the bar exams, he added to that knowledge while studying for them. His autobiography does not mention his attending any lectures, and nor does he refer to attendances at court, but he does record that he studied hard, assiduously reading the recommended books from cover to cover. On his return to India, Gandhi must have had a brief period in which to enjoy the prestige of having been called to the bar in England. But given his disastrous first case at the Bombay bar, that period cannot have lasted very long. Nevertheless, once in Africa, and when he'd overcome his crippling diffidence and had the experience of legal practice, it seems likely that at times the fact that he was known to have been called to the bar in England and the perception that as a result he was probably worth listening to would have been of assistance to him in his role as a political activist. Overall, one cannot help being left with the impression that any knowledge or advantage which Gandhi may have derived from his membership of the Inner Temple and used to his later advantage in his great endeavours can only have been negligible. The conclusion, therefore, must be that the suggestion made by the anonymous persons referred to in the Inner Temple paper, that at least an element of what Gandhi achieved was attributable to his legal and advocacy skills training whilst in London, can only be described as being without any sensible foundation at all. So lastly, Isaac Pixley Karsemi and South Africa. The African National Congress, the ANC, now the governing party in South Africa, is celebrated for the leadership of Nelson Mandela and his negotiation of the peaceful end to the whites-only rule in South Africa. Mandela was released after 7 years in prison on the 11th of February 1990. The ANC was not the only organization in South Africa dedicated to the end of apartheid, but ultimately it was the one which was paramount and most effective. Nelson Mandela was elected president of the ANC in 1991. A new constitution for South Africa was negotiated. A fully democratic election followed in 1994. And on the 10th May that year, Mandela became the first president of the newly cleansed state. He's remembered across the world as an icon of reconciliation and forgiveness, and for his leadership of the ANC to a plural democracy, which was crafted to enable all persons of all races, languages, and opinions to live in harmony. In January 2012, whilst in South Africa, my wife, then of only 36 years, though a Gujarati, had been born in Cape Town, I read an article in the Cape Times, the daily newspaper in Cape Town, from which I learned that the centenary of the founding of the ANC was nigh, that more than anyone else, a certain Pixley Isaka Semi had been the founder of that organization, that he'd been educated at a school in Massachusetts, at Columbia University in America and at Oxford, and that shortly after his return to South Africa in 1911, he'd been instrumental in the founding of the ANC. Until then, I had rather assumed that the ANC had been founded by Mandela's generation. So was it true Was the organization founded in 1912 and the organization of the Mandela era one and the same? Minimal research confirmed that the two organizations were the same. But Isaac Pixley Ka Isaka Semi, whom I shall call Semi, who was he? After further investigation, I discovered that he'd been called to the bar by the Middle Temple in 1910. With my interest quickened, I wondered whether he was rightly credited as the founder of the ANC, and whether as such he is to be credited with having contributed in any way to the ultimate success and achievement of the ANC under the leadership of Mandela. Semi was born in Natal on an American Christian mission in 1881. The mission, the Reverend Pixley, from whom presumably Semi got one of his names, took an interest in him, and when he was 16, arranged for him to go to the USA, to the Mount Herman School in Massachusetts. From there, he went to Columbia University in New York, graduating in 1906, and thence to Jesus College, Oxford, where he read law, obtaining his degree in 1909. It seems probable that he joined the Middle Temple whilst at Oxford, as he was called in 1910. The article in the Cape Times further informed me that Semi had issued the call for a meeting of Africans in Bloemfontein in January 1912, when a new national organization was formed, and that he gave the keynote speech at that meeting. The organization was initially called the South African National Native Congress, the SANNC, but in 1923 it changed its name to the African National Congress. The constitution which it adopted in 1919 included the statement that one of its objectives was to agitate and advocate by just means for the removal of the color bar in political, education and industrial fields, and for equitable representation of natives in parliament or in those public bodies that are vested with legislative powers or in those charged with the duty of administering matters affecting the colored races. The case is that it was he who recognized and provided the stimulus and inspiration for a national movement, and that he lit the torch, which was taken up by Nelson Mandela, Oliver Tambo, and Walter Sisulu in 1944, when they founded the ANC Youth League, and subsequently took over the leadership of the organization, turning the ANC in the 1950s into a mass movement. It cannot be suggested that this was the first organization in South Africa to enter the field on behalf of the non-white population, or that Semi was the first to call for unity. And I need to turn back for a moment to the early 1900s. After the end of the Second Boer War and prior to the creation of the Union of South Africa in 1910, whites-only constitutional discussions in a so-called South African National Convention were held for the purposes of establishing the shape and terms for the future government of a unified South Africa. Numerous meetings were held by Africans, Coloureds, and Indians to protest against their exclusion from these talks, but to no effect. In 1909, various groups from all over South Africa met in a South African Native Convention, the SANC. Together, they called for a constitution giving full and equal rights for all blacks, coloureds, and Indians. The whites-only convention produced recommendations which would perpetuate white supremacy and entrench the severely discriminatory practices to which the non-white population was subjected. The SANC sent a delegation led by a former Prime Minister of the Cape Colony, a Mr. Shiner, to make representations at Westminster. Seme and a student at Lincoln's Inn, Alfred Mangena, both of whom were then in London, joined the delegation. Their pleas fell on deaf ears, and the proposals of the White Convention were largely embodied in the South Africa Act 1910, entrenching white supremacy. The dismay of the non-white community was reflected in an editorial which appeared in an English language but African newspaper, Imvo Zohansundu, in August 1909. As a matter of passing interest, and you must forgive another one of my asides, at that time there was speculation as to who would be appointed the first Governor-General of the new unified South Africa. The editorial included the following comment: "We cannot credit the correctness of the rumour as to Mr. Winston S. Churchill's being in running for the Governor-Generalship of British South Africa. Such an appointment would be, we think, resented by the whole of South Africa. We want a man of fixed and steady principles, not a political mountebank, however clever. The attraction of a leader with fixed and steady principles and not a political mountebank will resonate with some people today, both within and beyond the shores of South Africa." The SANC was an ad hoc gathering drawn from disparate groups and individuals. Some groups and individuals with limited or special interests held back and did not attend the convention, Gandhi being an example. There were also divisions between some ethnic groups and tribes. The SANC had not been convened to create a permanent organization, and it did not do so. It was simply an ad hoc gathering of many different groups and individuals. And when its campaign had failed, it did not meet again. The editorial to which I referred included a plea for unity and for a new political party, which would unite the religious and moral forces, European and natives, of South Africa upon lines of righteous legislation, justice and fair play, irrespective of race or colour. And it is clear that the plea for unity chimed with the views of Seme and Mangwana, and with two other lawyers educated abroad, Richard Simang and George Monsio. Together they resolved to set up the creation of such a unified party. They proposed a new party to be known as the South African National Congress. This was formally established at a conference held in Bloemfontein on the 8th of January 2012, attended by hundreds of delegates drawn from across South Africa. This was the organization which grew into the ANC. Presently, at both the beginning and end of the conference, there was a rendering of the song which is now the South African national anthem, Nkosi Sikelel' Afrika, God bless Africa. As already stated, the article in the Cape Times to which I referred recorded that it was Seme who issued the call to Africans to attend the founding meeting in 1912. And indeed, it was an article by him published in a newspaper on the 24th of October, 1911, calling for unity in clear and persuasive terms, which effectively convened the meeting. In the article, it was also asserted that at the meeting itself, Seme was the keynote speaker and the main driving force behind the meeting's successful conclusion. It appears that he was also the founder of the newspaper which it was hoped would be the vehicle of the organization, Abantu Batho. Seme was appointed Treasurer General. He became president in 1930, but apparently autocratic behavior on his part led to his being replaced in 1932. The ANC, although infused with energy up until 1919, languished somewhat in the 1920s and 1930s, perhaps because its reliance on, quote, constitutional and peaceful propaganda, a term which appeared in its constitution, which remained the policy of the Mandela generation until 1961, even in the face of apartheid government's habitually violent responses, such as the Sharpeville massacre in 1956, to peaceful protests. In any event, the ANC was reinvigorated in the 1940s to become, in the hands of the Mandela generation, the mass movement of the 1950s onwards. It might be pointed out that the ANC founded by Seme was, in accordance with the stated objects of its constitution, essentially an African organization for the interests of Africans only, until its cooperation in the defense campaign and the formulation of the Freedom Charter with the South African Indian Congress, the Colored People's Organization, and the White Organization of Democrats, all that taking place in the 1950s. Hence, it might be argued that there is really no link between Seme and Mandela's achievement of a plural democracy. However, in the article convening that first meeting in 1912, Seme wrote, "The greatest success shall come when man shall have learned to cooperate, not only with his own kith and kin, but also with all peoples and all life." So it's a fair inference that the explanation for the more limited aspirations reflected in the original constitution of the ANC is that in 1912, the people suffering the greatest injustices and who are in most and immediate need of an organization to represent and protect them were the indigenous people. And that Seme considered that although that issue was a priority, it was also simply a stepping stone on the way. And that brings us to the remaining question. Seme had the reputation as someone who could work wonders with words. And it's clear that his determination, his skills of persuasion, both written and oral, and his organization skills played a significant part in the creation of the ANC in its early years. The question remains whether any of those skills can be related, even in part, to his time at the Middle Temple. The answer again is a qualified no. He first made his mark outside Africa in a speech which he made at Columbia University in 1906, entitled "The Regeneration of Africa." The text of the speech has survived. It won him a prize, which has been described as the university's highest oratorical honor. The speech included refutation of the racist concept of Black inferiority. There is a passage reflecting the racist attitudes and the injustice to Africans, injustices of which he must have been aware since his childhood in Natal, and which continued to power his activities on his return to Africa. The language of the speech has the flavor of an address by Martin Luther King, perhaps learned from his mission sermons in Africa or at churches in the United States. As can be seen, therefore, Seme was possessed of his skills of written and oral advocacy long before he ever landed in Britain. And after his years of education in the USA and at Oxford, it's improbable that he had not already acquired a thorough understanding of the principles of democracy. In short, it's highly unlikely that the rudimentary teaching provided by the Inns and the Council of Legal Education at the end of the first decade of the 20th century had anything to do with the skill sets which Seme already possessed, and hence cannot have contributed to his achievements in and after the founding of the ANC. Nevertheless, the badge of his call to the English bar may have stood him in good stead. It must have contributed to his impact on the audiences whom he addressed in South Africa. Everyone, including the white population, would have been impressed by his education and honors. The white liberals would have been eager to listen and support him. The white supremacists, in the face of such an educated and articulate African, no doubt feeling a creeping fear for their future. Indeed, the reputations of both Seme and his friend and colleague in England, Alfred Mangena, had reached South Africa whilst they were still abroad. This is evidence from the fact that the invitation to join the SANC delegation to Westminster in 1909 came from within South Africa at a time when neither had returned to Africa from their studies. So those are the three chosen selectees. And the general conclusions. Well, the general conclusions which I reached in relation to all three, Dickinson, Gandhi, and Seme, are disappointing to those who, like me, tend to regard the Inns of Court as having a general leverage of events the world over. But bear in mind the limited scope of my inquiry, and the three on whom I have focused are just three of many. By way of a postscript, in an introduction to a book by T.T. Daniel about the Inns, published in 1971, Lord Denning wrote this: "The best families always sent one or two of their sons to join one of the Inns of Court. From these Inns of Court went forth all the world over. These men carried with them the law which they had learned here. They took with them the rights of Englishmen. Their influence on the legal systems of the world has been immeasurable. When it came to drawing up constitutions, they played a leading part. Look at the Declaration of Independence. Look at the constitutions of Canada, Australia, India, and many others. You will see them drafted by members of the Inns of Court." Apart from the fact that the Declaration of Independence was drafted principally by Jefferson, who did not attend any of the inns, his legal skills having been acquired exclusively in America, Lord Denning's statement cannot be faulted. So there is some solace in that. Before finishing, I should just say something about my sources. As some of you may have observed, for sources I've relied heavily on two books about lawyers in the American Revolution, one by Master Stockdale and Justice Holland of the United States, and the other by Master Arledge. Both of these books can be purchased in the Treasury Office. I'm also indebted to the Inn's archivists for their assistance. Otherwise, I've gathered such information as I have been able to from a plethora of different sources. And a final passing note of interest on the issue of the influence of the Gujaratis. I understand that the current inhabitant of the lion cage in Regent's Park Zoo, the London Zoo lion, comes from Gujarat. The end. Sorry to have taken up so much of your time. If we have any questions, there is time for them.
No, thank you so much, Master Blunt. That was really interesting and informational to listen to. There are a couple of questions that have come in through the chat. I'll just have a quick read of them. The first question was, could the exercises you mentioned have been exercises in meditation, meditation, contemplation, a link to the spiritual roots of the inn, perhaps? I believe that was at the start of your session.
Yes, if we're talking historically, there wouldn't have been any exercise in meditation. But when you come to Gandhi, of course, he spent a lot of his time, amongst other things, meditating, and it certainly played a big part in his general conduct, and acquired, obviously contributed to some of the respect with which he was held. I think that's the best I can say in answer to that.
Thank you. The next question is, do you think that the inns should provide internal facilities to train and or facilitate for legal activism on independence and rights today? Or do you think forming good relationships with organizations like the Good Law Project that students of the inn may then interact with?
I don't think that it's any of the business of the inns to direct any training specifically to political ends. I think it should continue to limit its training to the study of law, teaching law, and the teaching of advocacy. I think that's all I can say about that.
I understand there are.
What I do think the inn should do, I've referred to the past practice of the benchers sitting much more frequently with the students at Hall. This does, of course, happen, but in my view, it doesn't happen often enough. And I think that far more of the dinners should be what one might term hall dinners, in which there is mingling throughout the meal. Obviously, the benchers there should be occasions at the more formal dinners when they can retreat to the high table. But otherwise, I think there should be far more integration. I think it would be easy to organize.
Thank you, Master Blunt. I was just saying that there are a couple of comments here as well that I'll pass on to you by email. But the other question we have is, firstly, thanks for spotlighting the roles that some members of the inns played in movements for independence in their home countries. Do we have evidence of the inns directly playing active roles in, for example, seeking to influence the British Parliament / government, that the independence route was the way to go? As a corollary, did the inns play any active roles in influencing one way or the other the Berlin Conference that concluded in 1885, also sometimes referred to as the partitioning of Africa, with all the leading European powers at the time present. Great Britain, Belgium, Germany, France, the Netherlands, and so on. Without the balkanization, partitioning that was clearly against the doctrine of equality under the rule of law, the subsequent movements for independence would probably have been mute.
Well, I think I can say with confidence that the inns themselves had no involvement whatsoever in the Berlin Conference. But of course, a good many of the politicians of all eras were barristers and members of the inns. And I cannot say who representing the British government was at the Berlin Conference, apart from, I think, Disraeli. And he, as far as I know, has nothing to do with any of the inns. Plainly, a good number of members of the inns were also members of Parliament, and undoubtedly in debates in Parliament, they would, but as personal individuals and not as representative of the inns, but they would as individuals had taken part in debates and had something to say on issues relating to the independence of any of the countries. But historically and rightly, the inn itself has never taken up political positions. I believe it didn't even do so during the 17th century Civil War. Although I think at one stage the inn might have given some silver to the king. But after that, I think they sat on the fence, as far as I can make out.
Thank you,
Okay.
That seems to be all the questions. I just want to say thank you again from the Education Department and on behalf of all the members in attendance today for this interesting talk, and also for spending so much time behind the scenes to prepare for this lecture and also to just run it. Thank you so much. We're ever so grateful.
Sorry to have taken up so long.
No, of course not. Thank you so much for all the information. The chat is, again, as usual, blowing up with thanks, with members expressing their thanks. Thank you again. Everyone, have a good rest of the day, and thank you for attending this afternoon. I'll conclude the session now. Thank you.